Denise, let me give this to you. And if you know how you can turn the sound off, but I don't know. Yeah, let's.
Hello, everyone. Thanks for coming. My name is Justin Wyatt. I'm a professor of communication studies and film media and the interim director of the Harrington School of Communication and Media. We're excited to host today's event. It is a signature event, the Amanpour Lecture for the Harrington School, and we're very honored to have our guest. For those of you who are visiting, I should tell you the Harrington School has many departments that all have one mission to communicate effectively. So we have communication studies, journalism, PR, sports media, film media, professional public writing, and the Graduate School of Library and Information Studies. So if you know of anyone interested in communication, please think of us, the school. So um, I'm very honored to introduce our president, President Mark Parlange, who wants to welcome you as well. Please give him a welcome. Thank you.
Thank you so much. Good to see everyone here this evening. This is something that we look forward to every year. It is a very important occasion. I just want to begin with our University of Rhode Island land acknowledgement. We acknowledge that the University of Rhode Island occupies the traditional stomping ground of the Narragansett Nation and the Niantic people, and we honor and respect the enduring and continuing relationship between the indigenous people and this land by teaching and learning more about their history and present day communities and by becoming stewards of the land we too inhabit. So we're really honored to have with us today our featured speaker, who is an extremely well known, preeminent First Amendment lawyer, Floyd Abrams. And we also discovered we both went to the same school. We didn't exactly overlap, but we were close. Um, Throughout his 50-year career, Floyd Abrams' landmark cases span from the Pentagon Papers to Citizens United to Clearview AI, and they have really helped define free speech as it is known today. His career has shaped major changes in law, public discourse, and civic action since the 1960s. He is the founder of the Abrams Institute for Freedom of Expression at the Information Society Project at Yale Law School. He has a national trial and practice and has argued frequently in front of the Supreme Court. I would like to also make a warm thank you to Christiane Amanpour for her steadfast support of the university and this lecture series. Her support enables us to bring some of really the finest journalists in the world here to URI. And these lectures have really been incredible learning experiences for our students, but actually for the broader community. And I think we really appreciate it. I'm also delighted to see a number of alums who have come back this evening to the university. So it's now my opportunity to turn the floor over to, I understand, Christiane Amanpour, who could not be here tonight, but send a video introduction of tonight's speaker, Floyd Abrams.
Hello, everybody. Thank you for coming. I want to thank Christiane Amanpour first. She is a great journalist and a great protector and user of the First Amendment. We're all in her debt, and I'm especially glad to be here in an entity sponsored initially and continually by her. And thank you all for coming. My topic today, as you saw in that title, is really how unique is the First Amendment, by which I meant to what extent is the First Amendment itself different than, usually broader than, the protections of free speech and freedom of the press elsewhere in the world. And I'll be going through a few examples of that, and at least in one case, asking you for your comments after I'm finished about one of them. But let me start historically. We began as a nation in 1776 with the Declaration of Independence, written by Thomas Jefferson. Thereafter, the Revolutionary War occurred, and thereafter occurred in 1787 a meeting in Philadelphia of representatives of all the former colonies, soon to be states of the country. And at that meeting in 1787, the focus, the entire focus, was on what sort of government will we establish? How will we decide which entity of the brand new, free American government could do what? At one point in the deliberations, one member proposed that there be not just that, not just an allocation of work and responsibilities to different government entities, but a Bill of Rights. And at that time, that moment, it was sort of early. Remember, everybody arose by horses in those days. So 3 of the new-to-be states were not represented, and the vote was 10-0 against having a Bill of Rights. And the justification there, well, I don't want to say it's too much trouble, but the justification was we're not here for that. We're here to establish a new republic. We're here to draft together with representatives from all over the new to-be government an allocation of power and responsibility. So let's not get into that whole business of what would be in or not in a Bill of Rights. Thomas Jefferson was then our first ambassador to France and was in France and did not attend, therefore, this meeting. He was appalled at the idea that there was no Bill of Rights established at this meeting in Philadelphia, in which all of the 13 colonies and about to be states were there. He wrote, "It astonishes me that the new government would not be expressly limited in power." And he said that it is a situation that no just government should resist, a situation of not having a Bill of Rights. So that was 1787. And finally, in 1789, in part because of unhappiness beyond Jefferson and his close friend, colleague, James Madison, about the absence of a Bill of Rights, there was a growing sense that with this new country, having the potential power that it later achieved, and having the authority that at some point they hoped it would have. And certainly in a situation in which the new government, having thrown out by force the British government that was running the entirety of what became the United States, that there had to be, Jefferson wrote, had to be a Bill of Rights limiting the government. And that was the purpose of it. It was to limit the power of the newly established government. Jefferson wrote, just to say it again, it astonishes me that the new government would not be expressly limited in its power. So they met at this later time to draft a Bill of Rights. And it was difficult, you'll be surprised to hear. Uh, the questions were many, uh, but there was a great deal of consensus on where to start. Um, uh, and the start was what became the First Amendment. And the first limitation on governmental power in the First Amendment, the entirety of the Bill of Rights, is, after all, protection of the individual from the government. That's what it's about. And so a Bill of Rights was drafted, uh, and the members who appeared to do the drafting were reasonably content with what they had, but they needed the states, the new states, to approve it. And at the first meeting of the Continental Congress, held in New York City, the issue came up of what would be in the Bill of Rights. James Madison was the basic author of the Bill of Rights, and he had said that the great purpose of the Bill of Rights was to limit the power of government. And the question was how much to limit it, in what circumstances, in what way. Uh, and they drafted what we have in the first 10 amendments to the Constitution. And the First Amendment, of course, contains, it starts with Congress shall make no law. So it's a limitation on Congress in the new government. It starts with freedom of religion, moves on to freedom of speech, freedom of the press, and it remains in really the same language that was adopted in that time, which has left our judges with a decision-making authority to decide how to apply it to new threats or even old threats repeated as the years went by. Uh, what I'm going to focus on with you really is the part of the First Amendment which protects the freedom of speech and freedom of the press. It starts with Congress shall make no law abridging freedom of religion was the first that they had, and then no law abridging the freedom of speech or of the press. The press clause is something I've been working on for the last few years with a number of people trying to put a little more oomph into the Supreme Court and its cases involving freedom of the press beyond what freedom of speech protects by itself. And so what I thought I would do with a title such as How Unique It is to take three examples of cases that went before the Supreme Court at different times in our country's history. I thought I would start my speech with the Pentagon Papers case. Why not? Some of you were not with us yet in 1971 when that case came up. It came up very quickly, and the case arose out of then Secretary of Defense Robert McNamara during the war in Vietnam, which was going poorly in terms of our ending, our getting out of it, our limiting our casualties in the war. I mean, a very difficult time for the country and certainly for the leaders of the country. And Secretary McNamara decided, and I said, why don't I take just a fresh look at this? Give me a document which has everything I need to know. How did we get into Vietnam? Why? When? And what has happened in the years since we entered what then, 1971, seemed, I don't think he thought it was endless, but what could we do? How shall we think about it in terms of trying to get out of it? A study was done, 7,000 pages of the history of the U.S.'s relationship in and with Vietnam, starting basically in World War II, where we aided the French with respect to their ownership, so to speak, at that point of Vietnam. They were not an independent nation at that point. And going up to the time in 1971. It was a controversial document because it really was a no-holds-bar one, which revealed that a number of our presidents had not leveled with the public about the degree to which we were getting into Vietnam and the difficulty of getting out of Vietnam. So by that time, we had a draft again, the first since World War II. Young Americans were going to Vietnam, were dying in Vietnam. And so McNamara's question that he put to the group of people who wrote the Pentagon Papers was, how did all this happen? And a little bit of what should we do, which never got written because no one had any idea really of what to do. But in terms of what the situation was and how we got there, it was an embarrassment to a few American presidents. And that would be clear on its face. The that reality was one reason that the release of the Pentagon Papers to the public was not even considered. But more than that, there was a lot in there which had not been revealed. Not material that I think it's fair to say really would have interfered with our military efforts in Vietnam or indeed our efforts to find some way out, face saving or not, of that war. Every page was stamped top secret, sensitive. The cover page was stamped top secret, sensitive. Top secret is defined in the statute as being material, the revelation of which would do significant harm to the country or its people, and its people. So the position of the Defense Department, the position of the United States was this is secret. All 7,000, all 7,000 pages. And of course, the New York Times obtained a copy of it. How they got it is still in dispute. You won't be surprised about who did what, who knew what, etc. But they got it. They got a copy of it off the computer of one of the individuals who was involved in drafting it. And so we had a great legal battle. That's not our topic tonight. I'm not going to stay on it except to say that for a period in the middle of June to early in July, there was litigation, first in the Southern District of New York, Manhattan, brought by the United States to get a court order barring the New York Times from publishing anything from this top secret, sensitive document. And the case went from the district court to the Court of Appeals to the Supreme Court. It's a great case to work on. And when it was all over, early in June, just like 10 days was the case for all three courts, and the decision of the Supreme Court, the New York Times won. They won in the broadest sense that the court denied the government's effort to suppress or require the suppression of the Pentagon Papers. We won because on a broader level, this had already come to be viewed as a confrontation of broader than the war in Vietnam itself, of the answer to the question or addressing the question, who gets to decide what? If a newspaper has information like that, particularly because it was or was supposed to be top secret, how much has to be proved for the government to get a court order barring publication, or depending on the way the government viewed it, what do we have to show in order to save the country from whatever harm might come from publication? I'll answer the second question first. A lot of years have passed since 1971, and there doesn't seem to have been any harm from publication. The Times was careful not to publish anything of military value and not to publish anything about efforts to work out some sort of agreement to end the war. But where it came down hard was the sort of how did we get into it, and how slowly, more and more, nobody's seeming to be there to think through how do we get out of this country, or how bad does it have to be for us to have to stay in Vietnam? How much harm would it do to the country? The vote was 6-3 in the Supreme Court for the Times. The ruling of the court was what the government was asking for, is what is known in law as a prior restraint, censorship, a limitation on what the press could print, and that the government had failed to prove that what would happen if publication were allowed would really imperil the country or our forces or us as a people in some way. The key moment in the case, I believed and believe, was when the chief Times lawyer, I was high on the team, but he was in charge, Alexander Bickel, a professor at Yale Law School at the time, and for whom I had taken courses when I was a student there. This was Bickle's first case. He had clerked for Justice Frankfurter on the court, but this was his first case of any sort on his own. And Justice Stewart asked him the following question. Suppose when we go back to our chambers and we read all the pages that everyone is telling us to read out of this 7,000 pages, we think that there's a pretty good chance that some young American who had the bad luck to have a high draft number, there was a draft then, will die. Are you telling us? Are you really telling us that if that's what we think, we can't enter a court order barring you from publishing it? Bickle's first answer, I used to tease him about this long after the case, was, well, I'm sure when you go back to your chambers, you will not find that. Stewart looked at me and said, this is a hypothetical question, and what I want you to tell me, if we decide that a life of one American soldier would be imperiled by this, are you really saying that in that case we should still deny the prior restraint, the injunction sought by the government? And Bickle gave what I believed was the absolutely essential answer of no. If that's what, I'm sure you won't find that, but if that's what you conclude, no, I can't tell you then that you can't enter an injunction in that situation. The next morning, the American Civil Liberties Union filed a brief of a sort I'd never seen before. There are lots of amicus friend of the court briefs filed, but never after an argument. The ACLU denounced that answer as going too far, and I exaggerate only a bit, selling out the First Amendment too easily. In any event, that answer, it seemed to me then and now, was essential. And while some members of the court, in their separate opinions, a few of them said we're not really persuaded, most of them said the government had failed to prove sufficiently that the dangers were all as grievous as they were claiming. And so we won. All this occurred within 2 weeks from the initial filing by the government through the decision of the Supreme Court, which is to say 3 different courts. A district court ruled in our favor. The Court of Appeals, I won't take your time to say what they said because it's still not clear to me, but we didn't win in the Court of Appeals. And then the Supreme Court with its 6-3 vote in our favor. And so we had that decision. That decision is still cited. And that decision is unique in every Western country that I've sought to check it with. My wife and I, by chance, had plans to go to England and Israel, where she's from, right after the case. It was very clear in both those countries we wouldn't have had a chance. But everyone, lawyers, judges, that we spoke to. And I think it's fair to say in general that but for the force of the First Amendment and the willingness of the court, and it's not easy in the middle of a war with soldiers dying, the willingness of the court to say, no, we are not going to make a newspaper stop publishing what it has and what it chooses to publish. uniqueness. I don't think any other country would have ruled the same way. Apart from the two I mentioned, I've talked to lawyers who do constitutional work, and back then did constitutional work throughout Western Europe. They all agreed that if their government went to court about a document, again, top secret, sensitive, all over us, in a war, no less, uh, we wouldn't have had a real shot at it, only because of the First Amendment, only because of the court's adherence to it, willingness to abide it. Did we win? Indeed, two of the justices, Stewart and White, said we're not persuaded by the times that nothing bad will happen, but my language now, not bad enough, not enough proof of not enough harm, certainly not enough deaths as a result. And looking back on it, one thing that struck me then and now is how clear it was to the lawyers elsewhere in the world that I spoke to and have spoken to now through the years that in their democratic countries, that their press would not have won. And that was because of I say the First Amendment, but in particular, the proposition that stems from the First Amendment that prior restraints, court orders barring publication, are about as inconsistent in almost any circumstance with the First Amendment as could possibly be the case. So I cite that as one example of uniqueness. Here's another going back a lot of years. 1941, we were not yet in the war, which of course we came in December, but we were working, the country was working very hard to arm, to get materials to our allies, to build up for what looked like a real chance of our being drawn into or choosing to join the war. In California, there was a situation on the docks in which a new union was had just been really formed and was attracting workers. Members of that union got into fights with non-union workers about joining the union and other matters of that sort on that topic. And a number of people were convicted of the crimes, the fighting crimes, the beating people up crimes, and the like. And the issue came up a number of months, I think 6 months, after particular people were jailed, of whether the judge ought to grant probation to them. Their lawyers had asked the judge for probation, served enough time, etc., etc. The motion was pending and was about to be argued, and the Los Angeles Times published an editorial titled "Probation for Guerrillas?" which argued that it would be a, quote, serious mistake if the judge granted probation, which said that no purpose in ratifying the Bill of Rights was clearer than that the security of the people had to be protected. And so in very strong language, the LA Times, at that point, the centerpiece really of newspapers in California and in the West Coast, was taking a position about what the judge ought to do. In England, that would be a jailing offense, then and now, for a case pending in front of a court, for the press to weigh in and urge him, in this case, not to grant probation, and indeed urge him for a longer sentence and a tougher sentence. Under English law, then and now, uh, that is something that is not permissible by the press. The Supreme Court had never had a case in which claims of freedom of the press and claims of wanting to protect judges from the pressures of being accused or told what to do by the press during a case had come up. And in a 5-4 decision, deeply, deeply felt, the words still fly off the pages. The court ruled in favor of the Los Angeles Times, saying that in so many words and with great clarity, the press has to be allowed to speak out on public issues. This is a public issue of what the judge ought to do, and it is protected speech. The 4 dissenters said, and if anything, in louder language, this is the violation of what is still, and indeed is still, English law. It is a violation of law around the world of democratic countries, which is the press can't impose pressure on the courts and thereby interfere or seek to interfere with the purity, so to speak, of the judicial process. And very, very angry opinions on both sides, particularly by the dissenters, saying in substance, this is the first case in which we are saying in so many words, certainly, that we don't really care about the fairness of what happens in our courts. More important for the press to be able to weigh in. In England, it's worked out just fine the way it is, and still is, in England. That's a jailing offense to try to influence a judge during a case about what to do. And in America, the opposite is true. In these circumstances, that this is a situation of the uniqueness of the First Amendment and its power in the courts. It's a very controversial opinion, and I would say amongst legal scholars, it remains a very controversial opinion, but certainly a one with uniqueness to it. The third is still going on. It's not a case, but it's a subject. The title of the subject is The Right to be Forgotten. What happens if somebody has done something bad and it's in Google? A guy in Belgium, for example, automobile accident, his fault, someone dies in the local paper. He goes to court and he says, this is my only Google listing. I'm not a public person. I had a bad day driving. I went to jail for a few days. It's now years and years later, and all anybody would find out about me is that I ran someone over 10 years ago. And you, Google, ought to, in effect, revise your links so as not to carry this. That when you're asked in a situation like this, you ought to, you must not carry it. That is the law in most of the world now. It's very Google oriented because Google at least is or was the entity which carries so much material from the past and doesn't really review it to see if it's still newsworthy. Google's position was you ought not to be able to tell us what to carry and what not. And in the European Court of Justice, Google lost. A decision was entered there, and it is still the law there, that in circumstances where the material is no longer newsworthy, my word, but that's what they're talking about, no longer newsworthy, if somebody asks that it be deleted from the links of Google, that Google has to do it. My view, we have not had that here yet. My view is that the court would say, and I think they should, that that's unconstitutional. I've talked to editors of smaller papers here who have big old volumes on their shelves of their newspapers through the years. And no one is saying they have to throw that away, but a lot of that goes on Google or its equivalent. And the question there then is what is our law? What should it be? We haven't had cases really yet on that. We've just had discussions. I wrote an article for the New York Times Magazine some years ago now about this, arguing that the result likely would be what I thought it was, which is that this is freedom of the press. Newspaper writes an article. The article isn't libelous. The article is true. In fact, you're telling it what, it's got to destroy the old stuff. And of course, the answer of the other side is there no forgiveness? And particularly if a legislature decides, and ours have not, but it could come, if a legislature decides it's against public policy, it's harmful, dangerous, unjust to link the person only with his or her worst day. In England, they had a case very recently, I mean a year or two ago, in which an accountant had been found guilty of some sort of transgression, went to jail for a few years, and a number of few years thereafter, under English law, he could go to court and say, "Free me from my my being listed with law enforcement as a violator of the law, since I behaved well, since what I did was bad, but it could have been worse, etc." And that sort of ruling is allowed in England to sort of give you a clean slate if what you did wasn't awful enough and there's no reason to think that you'll do it again. But where the question is, can the press refer to the prior one? And again, we get back to Google. Can Google keep it if there were a request to delete it? We don't have an answer, really. I think our courts would say the same on that as in other cases. The interesting part of that to me is that there was a judge who decided in England that it was time to move on, not hold this guy responsible anymore, and to delete from the criminal files all the stuff about what he did, because it's done. He paid his price. We don't believe he's going to do it again. Uh, it's an interesting subject, I think, for us to think about. Let me conclude with this thought. I want to read to you from other constitutions, two other constitutions, in which countries have sought to deal with what we would call the First Amendment issues. One of them, in their Article 19 of their Constitution, says every person shall have the right of freedom of thought, conscience, and freedom of speech and press. The second was citizens are guaranteed freedom of speech, the press, assembly, demonstration, and association. The first is the country of Eritrea, and the second is North Korea. Uh, those two countries are literally at the bottom of the list that a journalistic organization has prepared of what countries provide the most protection for free speech and free press, down to what countries provide the least. These two that I've chosen are the two at the very bottom of the list, the least protective of free speech and free press, yet they have that language in their constitution. A group called the Reporters Without Borders, a reliable international organization, described these two as the most brutally repressive nations in the world. And I cite that to you as I conclude, just as a way of saying both how hard it is to speak with generalizations entirely about this subject, but also about how countries ought not to be judged simply by the language that they put in their constitutions, but the reality of how they behave. That's it. Thank you all very much.
If you want to sit over there.
Over there, yeah.
Boy. Good afternoon, everyone. My name is Dan Hunt, and I'm the chair of the Journalism and Public Relations Department. And on behalf of our department and the Harrington School, we want to thank Floyd for that very engaging talk. I had the pleasure of accompanying Floyd today while he had lunch with our students and met with the editors of our student newspaper. He also visited a news media law and ethics class, and students get to ask him questions, which is always my favorite part of the visit, when he gets to interact with students like that. So now we're going to have an opportunity for folks to come up to the podium in just a few minutes and ask your questions of Floyd. So our time's limited, so I'm going to moderate the discussion and I'll get us started. But just in a few minutes, if you have a question, come on up to the microphone. Thanks, Floyd. All right. So to get things started, Floyd, in your book, The Soul of the First Amendment, in the introduction, you make a very important distinction between the First Amendment applying to government and not private entities. And I've seen that distinction come up recently with some of the things that have happened with Jimmy Kimmel and FCC. From a media law perspective, why is that distinction so important?
Well, historically, certainly the Constitution only imposes limitations on the government. We can have statutes, criminal statutes. Constitution is not there unless they're challenged on one ground or another. But the on the ground reality is that people are free to do all sorts of things so long as the law doesn't bar them. I mean, it's as clear as that. The tension that some of the examples I've said are engaged with is that there are some situations in which the law would bar if there were no constitutional protection for speech. That is to say, that there are circumstances in which if we didn't protect freedom of speech because we were afraid of the government controlling the speech marketplace, as it were, if that didn't happen, if all we were saying is the government, for its good reason, they were elected, their view is that such and such shouldn't be said. If there weren't constitutional protections, they could do it. They have the power to enact legislation, and unless there's some constitutional basis for the legislation falling, that would be the law. And so one of the remarkable things is the inherent tension here between the decision-making power of a speaker or publisher, the power of Congress or a state legislature or a policeman to say, you, we are protecting the public, you can't do that, when the doing it is speech. Yeah, if someone is screaming in your ear, yeah, a policeman might come. If someone is threatening you, it's words, but those words aren't protected by the First Amendment. But in the sort of situation that I've been described, I think Christiane Amanpour would share my view that that's a good thing.
Thank you. I have one more. In the PBS documentary Speaking Freely, Jamal Jaffer states that the Pentagon Papers case is one of the key pillars of press freedom in the United States. You mentioned the Reporters Without Borders Global Index of Press Freedom during your talk. This year, 2025, they said, and I'm going to quote them, after a century of gradual expansion of press rights in the United States, the country is experiencing its first significant and prolonged decline in press freedom in modern history. What do you see as the contributing factors to that decline? And I think my follow-up is, what's the path forward?
I wish I could solve it. We are moving as a society in a direction in which there have been more attacks, more threats to the press than has been the case previously. We're not moving in the right direction. Now, that said, that's not because the First Amendment has changed. In part, it's because the threats come from other bodies of government that at least have a plausible basis for saying that that would be harmful to be revealed. Though I'm the last person that will try to outline for you what those situations are, lest you go and do it. But it's a constant problem, and with new technology, we have all sorts of new issues. In a way, about what is speech? I mean, how shall we characterize the putting together on film a political figure saying something she didn't say, which has gone on very recently. What, if anything, can we do about that? It is still political speech. It is a way of mocking the person. It is a way of criticizing the person. But it's not true. It's not true that the person said it. And it's becoming easier every day as technology gets stronger in this area every day to make it seem as if people are saying things they never said. And that's a continuing problem. And again, I want to be clear. It's not that there's no First Amendment side to it. I was just in a case in California about a statute which would ban, in effect, saying that someone running for office said something the person didn't say, which is a very loose statute in terms of the potential for being misapplied or dangerously applied. But with the sort of technology that we have now, and just imagine the technology we could have in 5 years. I think we're going to have a lot more litigation. I mean, lawyers get in trouble now. They should know better, but they get in trouble by using AI to help them write briefs. Or worse yet, I don't blame the lawyer for this one. The AI device provides a whole opinion. He had a case in Oklahoma. He wasn't from Oklahoma. He's writing a brief about Oklahoma law. He puts into his computer like a case saying such and such. The case comes out. It's not so. It's the machine that wrote the whole case. Exactly what he wanted. That's what he wanted, was an opinion saying that. Here's an opinion written in language a judge could have written, but didn't. And so, yeah, I mean, on the most obvious level of this, yeah, lawyers have to be careful, and lawyers have gotten in trouble, and lawyers now teach other lawyers, before you use anything from AI, go do this and that, check this, check that. But I'm not just speaking of an AI issue. I'm talking about the explosion of new technology, which leads to new issues of this sort about what is reality and what is not, and what may the law do consistent with the First Amendment in limiting that sort of speechy, but maybe not speech material.
Thank you. Before we take questions from the audience, Floyd, I think you had a question that you wanted to ask our students in the audience.
Yeah, I was really interested in my second example, the right to be forgotten. The idea of saying Google is responsible and can be held liable for continuing after being on notice, et cetera, but continuing to tell the truth about something that happened years ago in circumstances in which the machine doesn't pick it up, or for whatever reason, it's no longer so. In situations where the technology, one could say, is the villain, the speaker. And so far, what we've said in the law, that makes a sort of sense, is no excuse. We don't want to hear you say, you go check it on your own. But the more we go down the road of ever faster and smarter technology, the less it may be that people will be used to doing what? Why do I have the technology if I can't rely on it? So that I was interested in whether any of the students, as they use and live with in a way that I certainly haven't, what do they make of this situation?
Any students want to take that for us? Any non-students want to step up to the mic? Yeah, sure.
We used to have to go to the library and look through indexes and indexes and indexes to find that information we were looking for. So it would still be out there. It's just more at our fingertips than it ever was. I mean, we could go to microfiche We could go to, back hundreds of years into indexes, journals that have been now indexed from the past and find the information. So it's still going to be there. It's never erased.
So what do you conclude from that?
That it's just more at our fingertips. So it's more readily available. But I don't think you can erase the past.
Yeah.
I would contend right now that I'm not sure that I would agree with you that is a case that the U.S. right now would say, oh yeah, that's not because the current resident of the Oval Office went to the Supreme Court and said, I want January 6th stricken from Google. I'm not sure that I think that it would be such a simple case.
You're wrong.
What about newspaper archives?
Yeah.
Some of us back in the day were in publications that had librarians.
Yes.
So if suddenly you came across something you had to write about, you rang up there and you literally ran over to the library and had. I worked for a publication with 3 or 4 librarians, and it was all there, and we could then incorporate it into our stories. So now it's just as you were saying, it's just an easier method. You Google something, or you go to your internet archive that's now digitized, your newspaper archive, and use that information. So I'd be curious to see if someone ever just challenged that. In Rhode Island, we now have criminal expungement of sometimes 5 or 10 years. But I've noticed a couple of times in the newspaper articles referring to somebody past 20 or 30 years ago and mentions that. And I don't think there's been a case brought now that says.
But is it a crime?
Yeah.
Yeah.
Crimes now are expunged after 5
That's very interesting.
years. And yet I know that recently I was reading an article, probably based on their digital archive, that they were able to call up and then repeat what this person had done maybe 20 years ago. So that I'd be fascinated to see what happens if suddenly a publication wants to go to their archives and write about somebody or an incident. And it's usually things that technically are not in the criminal record.
Right. No, that's a serious point.
That's a good question. Does someone have another comment either on this topic or a question you'd like to ask Floyd from either his talk or his decades of experience fighting for the First Amendment?
It's good, everything is okay.
Just a kind of a very simple question. What is the press today that we are protecting? Since all the discussion of technology, the question is, what are we really protecting now? Because so much of the old definition of the press was newspapers or TV or radio. So how do we answer that question in this discussion?
Well, first it'll be another evening. But that's you're right. It's hard, and one of the things that's fading away, of course, are newspapers and magazines. I couldn't believe I picked up the New Yorker. You remember, the New Yorker used to be that big, but there are no ads anymore. And if there are no ads, the end is coming. But yeah, you make a good point.
Yeah. Questions from the group? I know there were some student questions. I'll ask another question from my list too. One of the things that came up today in the news media law and ethics class were shield laws. And there was a discussion that a student had asked about I don't know if the student asked this directly or it came up, but should there be a federal shield law? And you've worked hard to protect journalists who had a confidential source in the past. Why do you think we won't have it, or maybe I should frame it that way? Should we have a federal shield law? And if we are going to try to have one, how do we go about? Why won't we get it? Why won't Congress approve it? Because that's what came up in class.
Well, I think the on-the-ground reality is that Congress is much less afraid of the press than it used to be. And at least on the Republican side, generally angry rather than sort of praising. I'm not saying they have to praise anything. I'm just saying as my sense of the reality of it is that for whatever reason, and this didn't start yesterday, there's been an antipathy by the Republican Party to the press as it was. And the current situation is that what we at least would agree with each other is the press is less important all the time and in a way less threatening because of that, but also more inviting as a target. I mean, some of the claims of the president against the New York Times, for example, a lawsuit in Florida, is just as a legal overview, impossible to succeed. But does it harm? Yeah, it does. No newspaper has money these days, for one thing. And fighting a lawsuit, and again, well, the president is a special case, but in other cases as well, it's an awful lot easier now, an awful lot less necessary now to have to justify to the whole newsroom why you're apologizing or taking back something. Well, we didn't really mean that something, which weakens the press enormously in terms of dealing with phony claims. I mean, if you're going to settle this and that and that, and somebody brings a blockbuster lawsuit, yeah, maybe you'll have to defend it because I put that word in. But look, the New York Times never had, and I think still doesn't have insurance purposely for its journalism. I know that has been the case from the mid-19th century through at least maybe 5 or 10 years ago when I last knew it. I mean, on purpose, not to have insurance as not just a sign to the world, but because we're not going to take orders from anyone about what we're allowed to print. Maybe those days, have left us. They didn't have to have, for example, a no settlement policy, which is still their basic policy. We don't settle libel cases. We apologize, but if we make a mistake, but you want to sue, we'll fight it out in court. I saw a letter, which was a copy of a copy of a copy, but a real letter written by so-and-so in 1920 something, the then owner of the New York Times, criticizing his lawyer for paying very little. The lawyer was proud I got us off with just this. And the publisher wrote a letter and released it to the whole staff about how you violated our policy and you better not do it again. We don't settle libel suits. Them were the days.
We have time for just about one more question.
I just, the Pentagon Papers, how did that get through the court so quickly?
Which get to the court?
The Pentagon Papers.
Oh,
weeks and
yeah.
And would that be the case today?
Yeah. The question was, how did the Pentagon Papers get to the court so quickly? Everybody wanted it to. The Times certainly wanted it to. The Nixon administration wanted it to. They thought they were going to win. And like the press coverage. I mean, that didn't last. But like the coverage, because if you want to show how tough you are, you take on in those days the New York Times. Uh, but even profitable print publications now are so close to the edge that it must be very, very tempting. But just to go back to the old poem, in the case in which I represented the Times, I don't know, in the mid-70s, a sort of a frivolous lawsuit that we could have bought off for a few $100. And, the journalism wasn't great about it. It's nothing to be proud about, but we had a good defense. I had to beg the Times, let me settle it for a subscription. And they did. Yeah.
Let's thank Floyd for being here one more time. Just a second. So we want to thank Floyd for giving this year's Amanpour lecture, and thank you all for joining us. We want to thank Christiane Amanpour for her continuing support of URI and the work we do here. It brings incredible people to this campus, and we really love this series. So please join us for refreshments in the Welcome Center lobby. Maybe you'll get a chance to ask Floyd a question you don't want to ask on the mic. And thank you so much again for being here. Thanks.